Good morning, everyone. We'll get to some formalities and then we'll do some introductions and welcome our new members. David will start the live broadcast.
Okay.
Good morning. Hello, I'm Mary Jones. I serve as the chair of the Marriage and Family Therapy Advisory Committee for the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting, which is being conducted remotely by conference call or other electronic medium. Jardine, I'll skip her. Nicole Eitzen.
Here.
James Godby.
Here.
Chris Haben.
Here.
Marcy Lechtenberg.
Here.
Good morning. I note the following BSRB staff members are also present: David Fye and
Here.
Leslie Allen.
Here.
Next, David Fye will read a message concerning the meeting being held remotely.
This is David Fye, Executive Director for the Kansas Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On July 7th, 2022, we sent notice of the advisory committee meeting to all individuals who had requested notice of those meetings. The notice was also posted on the board's website at ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other media material have been posted on the board's website, and you may request a copy of the agenda by sending an email to david.fye@ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and the YouTube channel that allows members of the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And I did check the conference call before we got started. There's no individuals on that, but if I hear a beep and individuals join the meeting that way, I will let you know.
Thank you, David. And I note that Jardine has joined us. Welcome and good morning, Jardine. And for the rest of the advisory committee, there are 2 advisory members who could not join us today. We're going to start with our agenda review. So you should see your agenda in the packet that was sent to you. If we could just get an approval of that. I'll take a motion.
So approve.
Thank you, Jim. Do I have a second?
Second.
Thank you, Jardine. All those in favor, please say aye.
Aye.
Any opposed, same sign. Thank you. We'll turn to the next item of business, which is the review of the minutes from the June 24th meeting, also included in your packet. And as soon as there's a chance to review those, we'll take a motion to approve those.
So approve.
Jim made a motion to approve the minutes. Is there a second?
I'll second.
Thank you, Jardine. All those in favor, please say aye.
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 Any opposed, same sign. Okay, well, I'd like to extend a welcome to our new advisory committee members. We could start maybe with just a quick introduction of yourselves. We'll go around so that you get to know us a little better. I'm Mary Jones. I'm chair of this advisory committee. I'm going to hand it over to Chris Haben to introduce yourself and talk a little bit about what you'd like us to know about you.
Good morning, and thank you for welcoming me. I am Chris Haven. Let's see. I'm a professor of marriage and family therapy at Friends University. I serve in the Kansas City location of Friends' program. I've been serving in this role this is the start of my 22nd year. Been licensed as a MFT about that long. I'm an AMFT approved supervisor. I do some clinical private practice work, do a fair amount of post-grad supervision as well. I've served at a previous time on this committee and was interrupted when I had a chance to serve AAMFT in a leadership role. This September, I will be married for 30 years and have 2 kids, one in college and one who's a junior in high school. So I don't know if those are the things that you are looking for,
they're
Mary.
great.
If I said too much, I apologize, but I hope that
Not
helped.
at all. Not at all. Welcome back, I guess,
Thank you.
is best to say.
Yeah.
Nicole, we swing it over to you for an introduction.
Hi, my name is Nicole Eitzen, and I have been an MFT for almost 9 years. And I'm just going to start off by saying, if you hear crying in the background, I've got a kiddo that's at home in quarantine, and my mother-in-law's with her, and I'm actually recovering from gallbladder surgery. So it's very adventurous in our household right now. So if you hear that, I apologize. Yeah, I've been an MFT for almost 9 years. I graduated from the Friends program in Wichita, and I currently serve as a CCBHC program director at Horizons Mental Health Center, where we serve 5 counties. And I've also been there almost 9 years. My husband and I have been married almost 8 years, and we've got 2 kiddos. One that's 5 and she's about to start kindergarten, and then my youngest, who is almost 2. And yeah, I think those are some of the big things. Yeah.
Welcome, Nicole. Thank you for being here today. And Marcy.
Hi, I'm Marcy Lechtenberg, and I'm currently the clinical director for the K-State Family Center. I'm a clinical assistant professor there. I've been in that role, it'll be 6 years now, starting my 6th year. I worked as family with families in the foster care system, and then I worked in medical family therapy in Nebraska and Iowa before I came back and did a PhD at K-State. I completed that in 2014. I was there lucky enough to be there when Jardine was there, and so I've been in this role, and my clinical interests are in the medical family therapy area. I do see clients at the family center and through a very small private practice. Kelly and I have 3 adult children and 7 pretty special grandchildren.
Thank you very much for that. Welcome. Would the other advisory members just introduce themselves briefly, please? Go ahead, Jim. Thank you.
Oh, I'm Jim Godby. I'm the director for the Center for Clergy and Center for Clergy and Congregational Care, and I'm located in Wichita. This is my first year in Wichita for 20 some years. I was in Dodge City and serving Western Kansas. The center's primary focus is support groups for clergy, and also to take care of the needs of the different congregations around the state of Kansas. I've been practicing, seems like forever, and it hadn't been that long. But before that, I was a United Methodist pastor. I'm retired after 37 years, and I'm in my 15 years as a marriage and family therapist.
Thank you, Jim. Jardine.
Good morning. I'm Jardine Coleman. I know a few of you already from other things in the world. So I am currently the Director of Therapy and Recovery Services at Pawnee Mental Health. So I'm in Manhattan. I have been a therapist and supervisor and director with this agency for 8 years. I previously worked in foster care and recovery services as well. I also serve on the Elections Council for AAMFT currently. And I have no idea how long I've been on this advisory committee. I think it's been 4 years, I think. And so I think I'm on my last term right now. But I'm glad to have some new faces and looking forward to seeing where we go.
Thank you, Jardine. And Leslie Allen.
You're muted.
I always forget the mute button. I have been with the board for 23 years. I moved here from California, and this was the first job I got, and I've been here ever since.
That's great. Thanks, Leslie. And lastly, David, we'll hand it to you.
Great. Well, I'm David Fye, Executive Director for the Behavioral Sciences Regulatory Board. And Chris, Marcy, and Nicole, it's nice to meet you in person over Zoom. We've had some communications over email, but it's great to be able to put a face with a name. So I look forward to working with you all more on the advisory committee. And we have an item scheduled for later on the agenda that involves some training. So hopefully that'll explain a little bit more about your role on the advisory committee. But yeah, I've been with the agency now just coming up on 2 years in November. Prior to that, I worked for about 8 years for the legislature and the Legislative Research Department as a principal fiscal analyst. But yeah, I'm excited to have you on the advisory committee and looking forward to getting to work with you more over the coming years.
Thank you, David. We will just keep it with you and launch into your executive director's report.
Great. So at every meeting of the board and the advisory committees, I provide a report summarizing some of the activity of the BSRB here at the office. And then also I provide the advisory committees some updates from recent board meetings and then other items of note. So I'll go ahead and let you know of a few items. First, for the BSRB updates, we are still under some of the governor's restrictions related to the pandemic. So our meetings currently right now for advisory committee meetings and most board meetings are going to continue to be held remotely over Zoom. And so if you have any questions about that, let me know. Part of that has to do with the size of our office and conference room and being able to space things appropriately. But we will continue to go and follow this current process. And if that changes, I will let you all know. And then we can discuss options for potentially remote meetings or having some in person. We have a new hire for the BSRB staff. We brought on board a new licensing specialist. Her name is Emma Allen, and she's been with us now for a few weeks, and we're really excited. We are training her on some new duties and responsibilities. She is someone that we received authorization to hire in part because of some additional responsibilities we inherited from a bill that was passed by the legislature that had called for expedited time frame of licensing processes for military members, military spouse, and some other individuals applying for reciprocity. But we brought her on board. Our goal with training her is to train her on different areas of licensing. And then when someone is out of the office, we can shift her to whatever is the busiest or provide coverage. But if you get a chance to meet her in person, I think you'll be really impressed by her, and we're excited to have her on board. The last item I'll make in terms of the BSRB is every year on September 15th is the date that all agencies have to submit a revised budget to be reviewed. Those are submitted to the division of the budget under the governor's office. This will include the current fiscal year, and this is state fiscal year 2023 that starts on July 1st and runs to the following year, June 30th. We will also be submitting a new budget request for fiscal years 24 and 25. And so when we do that, we attempt to make projections on different costs and expenses, and then we submit those, and then the governor's office reviews those And the first week of January, when the legislative session is about to begin, the governor goes ahead and puts out recommendations for all agency budgets. And then during the spring, the legislature can make additional changes during the budget committees that meet in that process. So, but one of the main topics that I'll be working on for the next month will be putting in numbers into the system and continuing to meet with some of the vendors we work with to get revised cost estimates for some of the services that we get. In terms of some updates from the last board meeting, the board met on July 11th, 2022. Every July, by statute, the board elects a new chair and a new vice chair for the board. And at that meeting, the board elected Mary Jones to be the chair of the board for this current year, and elected Dave Anderson to serve as vice chair for the board. There were also 3 new board members that were appointed to the board. The governor appoints board members to the board, and the governor appointed Cynthia Schindel, who is going to be a board member for social work. She took the spot that was previously held by Carolyn Safran. Richard Nobles, the new licensed psychologist on the board, and he takes the spot that was previously held by Bruce Nystrom. And then Jim Kilmartin is a new public member, and he will be in the spot that was previously held by Leslie Seawester. One of the major items the board discussed at that meeting, there is a subset of the board, 5 members of the board make up a complaint review committee of the board that hears investigations and put together by our staff here, and reviews complaints against practitioners. That complaint review committee, or the CRC, has an investigation policy that they follow for a lot of their practices, and the board is in the process of modifying and revising that investigation policy. So at the next board meeting, it is expected that they will probably wrap up their review and changes to that document, and then we will go ahead and post the new revised policy on the board's website. The last item from the board meeting that I wanted to make you all aware of: every year the board tries to have a offsite planning meeting. It's usually a full day of meeting for the board, where the board discusses items that have been discussed over the past year, discusses items for the legislative agenda for the board. This year, that meeting is going to be held in Olathe on Monday, October 24th. So there will likely be one more advisory committee meeting for this committee prior to that date. But I wanted to let you all know that that meeting is scheduled for Monday, October 24th for the board. And so, so that will be the board's planning meeting that day. And then one last item I wanted to make you aware of: I was recently attending a conference. This was a conference by the National Board for Certified Counselors. It's a conference primarily for professional counselors and the regulatory boards that oversee those individuals. I was asked to present information to the attendees of that meeting. I was asked to provide a presentation on innovations in licensing, looking forward and back. So I spoke for about half an hour to the attendees, and I talked to them a little bit about some of the processes that we are currently looking at for the board and some of the work that the board is doing in Kansas. I mentioned licensing as a broad equation. And I mentioned that when we're looking forward, we mentioned a lot of things like potential multi-state compacts, and considering our licensure laws, statutes, and regulations, and examining if those should still remain in place. There's also things like tuition reimbursement programs, and there's a lot of focus on individuals coming in fresh on the one side of the equation. But I mentioned that there's also really important responsibility in looking at the other side of the equation. Part of that is individuals who are currently practicing, and making sure that we don't have or if we can be responsible about assisting individuals to stay licensed, there's some merit in continuing to help individuals stay licensed. Or if there's individuals who stop practicing, there may be some incentive in looking to see, can we have those individuals come back to the profession? There are currently a lot of discussions about workforce and different things like that. And a lot of that topic of conversation has focused on new individuals coming in fresh. But I thought it would be important to bring forward some ideas talking about making sure individuals continue to stay licensed, and also having those individuals come back to the profession as well. So it was well received. I also mentioned a couple other items about our office, and we got a lot of positive comments and feedback based on the work that everyone is doing here in Kansas. So I just wanted to share that with you. And with that, I will go ahead and end my report. And I can answer any questions if there's any questions from members of the committee.
Thank you, David. Do any of the advisory committee members have questions or comments for David? Okay, as always, lots of updates from the office. We're going to move into the next agenda item, which is the training for advisory committee members. So David, you are back on.
Okay, great. Well, I want to direct your attention to some of the documents that you received from me. There should be 4 documents that will be a part of this training. And so I spoke to the board earlier this year, and there's a benefit in having an annual training for board members, but also, the advisory committees assist the work of the board. And so it was the board's decision to go ahead and combine the trainings together. And so some of the topics that I'll be talking about today might involve board members a little more than advisory committee members, but I think it's important to go over some of that information first so that you can put the work of the advisory committee into the context of the overall work the board is doing and how the advisory committee members and you specifically can assist the work of the board as you go through some of the things that you're doing as advisory committee members. So those 4 documents in your packet, you should have one that's called Expectations of Board Members. Then there's an advisory committee policy, and then there's a guideline for public attendees at meetings. And then the last document, it's called Behavioral Sciences Regulatory Board and Advisory Committee Member Training. And this is based off of a document that was provided to us by a legal counsel from the board back in February of 2021. And so I'm not going to go through all of that document, but there's a lot of good information in there, and I'm just going to incorporate some of that into your training. So the first document, the expectations of board members. So previously, the board had a document called the Board Governance Policy, and they revised that about 1.5 years ago, or made some changes to it. And then that document was split into 2 separate documents, the expectations of board members and also the advisory committee policy. And so looking at the expectations of board members document, it notes that the authority of the board in terms of overall jurisdiction is that if it conflicts with any federal or state statute or regulation, then those federal or state statutes or regulations controls. So this expectations of board member document does fall below the other documents that have a higher legal standard. So federal, state, or state statutes and also regulations would come in priority if anything conflicts with this document. The mission statement of the BSRB is that in accordance with the intent of the Kansas legislature, it is to protect and serve the consumers of mental health services and the professionals that offer them through the issuance of licenses, resolution of complaints, and the creation of appropriate regulations accomplished through efficiency, fairness, and respect to all those involved. Just as a little bit of history, the BSRB was formed back in 1980 when the legislature took the body of licensed psychologists and social workers and put them together. And then over the years, other mental health professions have come under the board, and the board has grown accordingly. But it's really important to start off with that with the mission statement, because the board is a public protection agency. And so the #1 mission of the board is to protect the individuals who are receiving services. And part of that involves the responsibility to licensed professionals, but the #1 priority must be the individuals receiving those services. In section 3, it talks about some of the guiding principles of board members, and it notes that board members or that persons in Kansas should expect that board members oversee mental health providers and that they be licensed to be qualified, competent, and professional. And then that persons regulated by the BSRB should expect equitable and fair treatment in relation to licensing activities, disciplinary processes, and administrative regulations. The BSRB is to provide all services in a manner that is timely, cost-efficient, courteous, and competent. It should be led by ethical principles, clear policies, progressive thinking, and strategic decision-making, and the BSRB should respect the dignity and worth of all individuals. Under section 4, you see some of the services that the board and the BSRB should provide. We should process license applications and license renewals in a timely manner. We should take disciplinary action when appropriate, provide timely information to the public, maintain rules and regulations and statutes. And on page 2, there is a code of conduct for board members. Now, this is not comprehensive, but these are items that the board wanted to highlight. As I mentioned, the governor has authority to appoint board members to the board, but this was a document that was created by board members to provide some overall insight into what should be the expectation of members of the board. Under A, it talks about integrity of board members and that they should have no criminal or professional misconduct record, nor commit acts that would lead to investigations or complaints. They should possess sound moral principles. They should have courage of convictions to withstand pressures to be swayed from the public protection agenda. They should be honest about personal agendas and leave them outside the boardroom, should reveal any actual or perceived conflicts of interest, and appropriately recuse themselves from decisions or actions in the areas of interest, should not represent their personal opinion as that of the board, and should be limited to one unexcused absence per year. And some of those items in terms of representing their comments as the boards or conflicts of interest, we'll talk to in a little bit more detail when we get to the document provided by legal counsel. Under section B there, conflicts of interest, it talks about guarding against conflicts of interest. And it notes that board members should have no personal financial benefit as a result of service to the BSRB, except subsistence and mileage. A board member of the BSRB who may have a conflict of interest according to stated criteria should refrain from voting on the matter. Board members should disclose any relationship with any other agency or individual involved with the BSRB and shall be excluded from matters involving such a conflict. On page 3, you can see that board members that serve as part of an organization working in any way with the BSRB should inform the board chair. Board members should not accept any gifts or promotional items received as part of their affiliation with the agency for personal use, and should not use the agency's name or agency information for personal gain. Section C on page 3 talks about confidentiality, and it notes that the following items should remain confidential: anything that's discussed during an executive session, and any items concerning actual or potential litigation. And if you're not familiar with organizations that take executive session are specific motions that are made in a public meeting where the board goes into a private session that is not broadcast, is not open to the public, and there's a limited number of items that can be discussed during those executive sessions. So in case you were wondering whether something is an executive session or not, it should be aware to you, because there'll be a formal motion that will happen, and then we will discuss. The board members are probably going to go to a conference call or something away. And while that usually will affect board members, you could have executive sessions as part of an advisory committee meeting as well. So I wanted to make you aware of that too. On page 3, under board meetings, it talks about the board member composition. Board members, by statute, there are 12 members of the BSRB. 8 of those are professional members that are outlined in this section, and 4 are members of the public. The governor does have the authority to appoint or remove board members, and that has to do with basically they can appoint or remove members, and the grounds for removing members generally come down to legal concepts such as malfeasance, misfeasance, and nonfeasance. And it's a general definition of some of those terms. Malfeasance is when you do a bad action, but it's an intentional bad action that violates some of your duties as the board member. Misfeasance would be that you do something where it creates an issue that goes against your duty as a board member, but it was a result of a mistake. And nonfeasance generally has to do with your non-action when you have a duty to act. And I can get into those in more detail, but that's just kind of a general understanding. And so the statute says that those are really the grounds by which a board member is removed. That happens rarely, but I wanted to make you aware of that. Also on page 3, it talks about public meetings of the board. So the board meetings, the full meetings of the board take place on the second Monday of every other month, unless the board determines that there's a special meeting that needs to occur. Sometimes in the spring, because of legislative bills that come up with short notice, we might have a quick board meeting, but those meetings of the board, when it involves the discussions, those are all public meetings, and those are open to the public, and we provide notice and take care of those items here at the office. At the bottom of page 3, it talks about the chair authority and responsibility. And that continues on the top of page 4. It talks about the chair has the authority to preside at all meetings, to appoint members of the advisory committee, to appoint members of the CRC, and to appoint member of other ad hoc committees. It notes that the vice chair shall discharge the duties of the chair in his or her absence, disability, resignation, or death. And there are certain times where we have an official presiding officer at meetings. We have also passed, the board passed a motion that allows other members of the board to serve as a presiding officer in the instance that the chair and vice chair are unavailable. So if you have questions about that, we do have that recently came up within the past year. I won't comment on section D on page 4, but it talks about emergency executive secession. That's something that would rarely come up, but feel free to review that as you would like to. Under section 7, it talks about the board and the executive director relationship. So under that organizational structure, the executive director communicates any personnel matters that should be addressed by the board to the board chair, and then the chair of the board will present to the board those related issues. And then the executive director will communicate to the staff the board wishes, intentions, and policies. And one of the items that I do in my role as executive director is I have monthly staff meetings, and I provide them updates on anything that would involve them from the board or any changes in board membership, so they're aware of who could be contacting them about certain things. It talks in section 7B about delegations to the executive director. The executive director is the administrative head of the organization, serving at all times under the board. And the executive director will be responsible for implementing and executing the policies and activities approved by the board. He shall assist in the developing of the overall program and shall recommend policies and activities for consideration by the board. Under number 2, it says the executive director shall have sole authority to employ, eliminate, and fix the duties and salaries of other employees or independent contractors of the organization, subject to the policies, regulations, and limitations approved by the state of Kansas. And so I do have authority to go ahead and hire individuals to work as staff for the BSRB. However, any individual that we want to hire, the name of that individual and the salary we want to pay that individual have to be approved by the governor's office. So there is a check in place for that item. Under 7C, executive expectations, it says the executive director shall keep the board advised of BSRB activities by issuing a report to the board at each full board meeting, which summarizes pertinent information. The executive director shall prepare the agenda for board meetings in consultation with the board chair. And so Mary Jones and I do have meetings where we talk about possible agenda items for board meetings. And I meet with each of the advisory committee chairs in preparation for those meetings as well. And the executive director shall prepare the agenda on page 5 in consultation with the board chair for the annual board retreat, which shall allow for issues before the board that need in-depth consideration. And then for D, it says monitoring executive director's performance. The board shall, when necessary, utilize executive session to discuss issues concerning the executive director. The board shall also formally evaluate the performance of the executive director each calendar year and on an annual basis thereafter, with emphasis whether set outcomes are attained. And so one item that the board did last year was they went ahead and did a performance review for me. And if there's any items that the board would need to discuss in terms of personnel, that is always a grounds they can go into executive session to discuss personnel decisions. One item that's not covered here in the expectation of board members has to do with that complaint review committee for the board. There's a separate policy that talks a lot about that investigation policy, but just to give you some information about that, that is composed of 5 board members, 5 of the 12. It has a social work board member, a licensed psychology board member. Currently, there are 2 public members, and then 1 other member who is outlined from one of the professions, professional counseling, marriage and family therapy, or master's level psychology. Now, that language is in the context of being reviewed by the board for potential changes, but that is what's in the policy right now. So if you want to know more about the complaint review committee, feel free to take a look at that document. It is posted on the board's website under policies. Next, go ahead and turn to the second document that is titled Advisory Committee Policy. It's a short document that's just about 2 pages. As I mentioned, the board governance policy that was previously used by the board was split into the expectations of board members and also an advisory committee policy. And so I'm just going to highlight a few items in this policy. You should have all received a copy of this, especially the new members, to understand your role as advisory committee members a little bit better. But I'll just highlight a few things in this to put the work of the advisory committee in context. The advisory committee policy states that the BSRB advisory committee, as a creation of the board, has the purpose of supporting the board in carrying out its mission to protect the public. Members serve at the pleasure of the board, and actions pertaining to informing, licensing, disciplining of those persons regulated by the board are the methods for accomplishing that mission. And then the process the advisory committee utilizes is that it fulfills its purpose by addressing issues referred to it by the board through the advisory committee chair or the executive director. A committee may also suggest issues it believes the board should consider and refer those items to the chair of the advisory committee, who will report back those items or recommendations to the board at a full board meeting. Under the structure of committee, it talks about the chairs of the advisory committee will be members of the board. And then if their profession is represented on the board, the chair of the advisory committee will be a board member licensed in the discipline of the committee and appointed by the governor to represent that discipline on the board. And then any other board members appointed by the governor to represent that discipline on the board will serve as a member of that advisory committee. Where that comes into play happens to do with the social work board members and also the licensed psychology board members, because there are 2 of those board members. And so for the licensed psychology profession, 1 member serves as chair of the advisory committee, and the other member appointed to the board is an advisory committee member. It notes here that there will be a public member of the board on each of the advisory committees. And then it mentions that there will be a minimum of 3 non-board members and a maximum of 10 additional non-board members on the advisory committee. So you're going to have the member of the board who oversees that profession, you're going to have a public member, and then you're going to have a minimum of 3, maximum of 10 non-board members on the committee. It notes that the executive director is a non-voting ex officio member, and then the assistant director or licensing manager is encouraged to attend meetings. And then at times, the assistant attorney general representing the board should attend meetings when their attendance is requested. And that happens in rare occasions, but they are available to come to our meetings if we need them to come and discuss a certain issue. Under the next section, it talks about terms of advisory committee members. So terms of appointment are 2 years, and then members will be appointed by the chair of the BSRB and can serve up to 4 terms. Appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. And it notes here that the policies and procedures under which the BSRB board members are expected to operate will also apply to the advisory committee members. And that sentence there is very important because it also puts into context why I was informing you about the expectations of board members, because that sentence there indicates the policies and procedures under which the BSRB board members are expected to operate will apply to the members of the advisory committee. And then it notes here that the chair of the BSRB can remove members. So the remaining instructions in that advisory committee policy talk about the process of reviewing and considering new members. It's just important to know that your authority as an advisory committee is to have discussions and make recommendations. And then those recommendations are forwarded to the board, and the board has the ability to make official action. When it comes to adding board or advisory committee members to the advisory committee, what your jurisdiction is to discuss candidates for the advisory committee, to reach recommendations, but ultimately it's the chair of the board who has the authority to add members to the advisory committee. And it talks a little bit about that within the rest of the advisory committee policy. The next document in your training is also a short document. It talks about guidelines for public attendees of meetings. So you may have heard at the beginning of the meeting today, there was a short script that we read as this meeting is remote, but it also gave a little bit of information about something called the Kansas Open Meeting Act, or KOMA. And so this document is helpful to kind of get an idea of who could be coming to the board meetings or the advisory committee meetings to provide public comment or bring information to you. And then the process by which we let those individuals know that they should follow certain guidelines. So this document was adopted in January of 2022. It notes that the meetings of the BSRB and the subcommittee meetings of the BSRB, such as advisory committees, fall under the Kansas Open Meeting Act and are open to the public. It notes that the KOMA does not require state agencies to provide public comment to individuals. However, as part of the BSRB's public protection mission, the agency values the receipt of information and input from members of the public. And to ensure that all individuals are treated in a consistent and respectful manner, the agency created this guidance document to provide general procedures for individuals who wish to attend the board meetings or advisory committee meetings, as well as general guidance on topics relevant for public comment at these meetings. And so there's some general instructions about when we have in-person meetings. Those are generally going to be held at the board office, and there's some information about that. It does also mention that even though there would be an in-person meeting, those meetings will continue to be broadcast on the BSRB YouTube channel. There's some information there about virtual meetings or remote meetings, and those are what we are currently doing for most of our meetings. They're broadcast, so the attendees have a Zoom link, but to make sure that we can protect the feed itself, we have individuals who wish to view that meeting who are not going to be speaking. We direct them to the YouTube channel so that they hear all the same information and can see all the same information. But for individuals who are going to be talking, we provide them the Zoom information so that they can access the meeting and talk to the committee directly. At the bottom, it talks about general guidance for attendees, and there's some general information to avoid disruptions. And so they also know sort of how our meetings operate. On page 2, it talks about the procedure for public comment, and it notes here that the chair of the board and the chairs of the advisory committees will determine whether public comment will be allowed at each meeting. If time for public comment is permitted, the chair has the authority to determine the amount of time available for public comment. And then it notes here about the process that if any individuals wish to provide public comment, they should notify me with a certain amount of time before the meeting so that we can make sure that we have the chance to have a discussion about if something will be allowed for public comment. And then we note here that written information is not required if you provide public comment, but we note the value of receiving that so that we can provide it to the advisory committees ahead of time so that they're knowledgeable about what would be discussed. And if there is time for discussion, they can interact in that process a bit better. It also mentions that at the conclusion of the public comment, the chair may allow some time for questions or may move to the next item in the agenda. So the COMA does not require there to be public comment time, but if it is approved for certain individuals, it's important to know that it may just be time based on the number of items in the agenda where we might allow time for 5 to 10 minutes for someone to discuss an item, but then we'll need to move to the next item. So there may be discussion, but there may be other times that we'll have to move to the next thing immediately. And then we included one item at the bottom of page 2, topics relevant for public comment. And it notes here that as a state agency created by the Kansas legislature, the BSRB is governed by statutes and regulations, and information presented to the board or advisory committees should be relevant to those statutes or regulations governing the agency. It notes that the chair reserves the right to limit testimony that is, in the judgment of the chair, not relevant to the matters germane to the board or advisory committees. It notes that common examples of past public comment include requested changes to statutes or regulations relating to qualifications for licensure, fees, continuing education, or unprofessional conduct of practitioners. And then there's a note in here that talks about receiving other information, and it notes that the BSRB does highly value receipt of information that a licensee may have violated the statutes and regulations for the professions regulated by the agency. However, information on a specific practitioner licensed by the BSRB that should be filed as a complaint against that practitioner. And we have a process called filing a report of alleged violation. It's a standard process, and that is posted on the board's website under the complaint section of the board's website. And to make sure that we are treating individuals from the public and also practitioners fairly and consistently, we ask individuals to make sure they submit those complaints of alleged violations through that process so that we can handle those in a standardized fashion. So we indicate that that's not really suitable for discussions at the advisory committee meetings, but we do value receipt of that information, and we want to make sure that we fulfill our public protection mission by reviewing those and investigating those. But we wanted to give people some knowledge ahead of time concerning that topic. And then we add a link to where individuals can submit a complaint against the practitioner. So those are 3 of the documents as part of the training. Before I move to the larger document, I wanted to pause and see if any of you had any questions. No? Okay. Well, if you do have questions after the meeting, feel free to go ahead and send me an email, and I'd be happy to look into something or clarify something a little bit more. But I'll move next to the last document, and that is a fairly lengthy document. It's about 22 pages. This is titled Behavioral Sciences Regulatory Board and Advisory Committee Members Orientation. And this was a document put together by former main legal counsel to the board as part of the work of the board, so the BSRB is a small agency. We have 10 employees, including myself. And so to assist the work of the agency and the work of the board, we receive legal services through the Attorney General's office. We have a contract with that office, and For that contract, they provide services to us, main counsel to the board, and also they assist us with other items such as review of the complaints and complaint review committee actions. And so legal counsel for the board went ahead and provided this document, which touches on some of the statutes and regulations for the board, and also some other helpful items so that you understand your role as an advisory committee member, or if you're a board member, your role as a board member. So this document talks about the state of Kansas first, and that the state has a responsibility to regulate many professions. And each of these professions is regulated by a licensing board or commission, and it was created by the legislature in Kansas for the purpose of ensuring that licensing professionals are competent and do not pose a risk to the public. It notes here in the document that a professional licensing board is created by enabling legislation, which establishes a board's form, mission, powers, functions, tools, and implementation and enforcement abilities. And at the bottom of that page, page 1, it says, besides statutes specific to the board's authority is limited by the constitutional, equal protection, and due process rights, prohibiting a board from acting in a manner which results in disparate or inconsistent treatment of individuals that are similarly situated. On page 2, it notes that a licensing board may not impose more severe discipline on, for example, male licensees solely because of their gender, or a licensing board may not revoke a license simply because the board does not like that particular person. There are certain constitutional protections that are in place. In the next paragraph, it talks about the Kansas legislature retaining control over certain aspects of a licensing board. And so we do operate under the broad authority of the state of Kansas and under the legislature. As I mentioned earlier, the legislature did create the BSRB. One of the ways the legislature can continue to have oversight over the agency is that the legislature could pass a bill which would repeal the enabling legislation of the agency. So it could pass a bill to make the agency go away. Also, we are a fee-funded agency, and so we don't receive money directly from the state general fund for operations. When I say fee-funded, it means that we are funded based on the fees that we charge licensees as we regulate the profession. So we receive that revenue in, and then by statute, we provide 10% of it back to the state general fund. And we have a fee fund, which is where the rest of the revenue is deposited. And our operations have to come from that fee fund. And so every year, I mentioned we have to submit a budget. And you may be thinking, well, why do we submit a budget if we're not asking the legislature for money? Well, part of that is the legislature does have an appropriations bill every year. And even though the state of Kansas doesn't give us money, what they have the authority to do is to set a limitation on how much we can spend in a particular year. So even though we might have funding in our BSRB fee fund, they would put the limit at a certain amount, and then we would not be able to spend above that amount for that fiscal year. And so one of the ways that they could control the agency is they do have authority to lower that amount or put the amount per year of how much we can spend. And so I mentioned, the board must receive legislative appropriation in order to expend the money collected. And also the legislature could pass a bill that would change the makeup, scope, or the powers of the board. And so the legislature does have a lot of authority. In general, when I'm going to be talking about things like statutes or regulations, and some of those I mentioned a little bit earlier. So statutes are law. Those are items that were passed in bill form in front of the legislature and then signed into law by the governor. And so statutes are the end result of those bills when they went through that process. And so those provide the big, broad framework of the board's authority and what we have to figure out the details for. And when I say figure out the details, that's because we also have the process of regulations. And so regulations are where the board works through the day-to-day responsibilities or some of the details within the statutes of the board's responsibility on things like qualifications for licensure or information relating to continuing education or potentially programs that the board might approve. And so we do work under both the statutes and the regulations, but the statutes have to be passed in bill form, whereas the regulations are things where the board has more authority to discuss those and then recommend changes. And then that process involves a different pathway where those have to be made public. There's a public hearing and there's additional comments that get provided on those. and then those would go into effect. Back to page 2, I'm going to draw your attention down to the bottom of page 2. There's a paragraph that starts, the general purpose, whether explicit or implied, of a licensing board is to secure for the people of Kansas the services of competent, trustworthy practitioners, and to provide the public against, protect the public against unprofessional, unauthorized, or unqualified practitioners. The purpose of a licensing board is not to promote or protect the profession as a whole. Those functions typically lie with a private professional association. A licensing board accomplishes its purpose through licensing applicants who meet established eligibility qualifications, generally education, experience, and examination, and through the disciplinary process by which a license may be conditioned, limited, revoked, suspended, or otherwise sanctioned for the violation of a statute or regulation. And then under the functions duties of a licensing board, it notes here that in order to carry out its purpose, a board is granted or delegated powers and functions that similarly parallel the 3 branches of state government: executive, judicial, and legislative. It talks about the executive authority of the administrative function, and that's by which the board carries out its enabling act. The board is required to follow the Kansas Open Meeting Act and also the Kansas Open Records Act, or KORA, to ensure that the public's business is conducted openly. We have quasi-judicial authority, and that allows us to enforce the Enabling Act by holding quasi-judicial hearings to make findings of fact and conclusions of law and determining whether those facts have proven a violation of the law has occurred. And then it says, in determining the judicial capacity, most licensing boards are required to follow the Kansas Administrative Procedures Act. And that is generally referred to in our context as CAPA. So if you ever hear of CAPA, that's referring to the Kansas Administrative Procedures Act. And that is in order to achieve uniformity among various agencies of the state in respect to procedural safeguards. And then the BSRB also has quasi-legislative authority, and that is what I talked about a little bit earlier, to adopt those regulations in order to implement or interpret the Enabling Act with more detailed or specific requirements. At the bottom of page 3, there's a little bit more information about the statutes, regulations, and policies. So a regulatory board implements and enforces statutes and regulations, and at all times operates according to internal policies. In order to be effective, board members need to understand the differences between statutes, regulations, and policies. And I've already talked to that broadly, but essentially, as I mentioned, statutes are laws passed by the legislature, and they would not change until you have another law that changes that existing law. Or there could be cases where the courts might strike down a provision of the law. But at most of the time, a law is not going to change unless you pass another law. So if something is in statute, there's not a lot of flexibility to change that. Generally, the legislative process happens from January until June each year. And so if a bill is passed that year, often that bill will become effective upon publication in the statute book, which is generally referred to as July 1st. It could also become effective by publication in the Kansas Register, and the Kansas Register is a publication in the Secretary of State's office, or it could have a specific date of implementation that would be named in the bill. At the bottom of page 3, there's a section that talks a little bit more broadly about regulations. And as I mentioned, those regulations allow the board to adopt rules to further flesh out the general authority under the statutes. And there is a process by approving regulations, but in general, in your context, as it evolves the regulation and that regulatory process, what you will be asked to do sometimes will be to review regulations, and they're going to be called KARs, Kansas Administrative Regulations. And so KARs are what you are going to be asked to review from time to time, and then to consider recommended changes. And if you do vote to recommend a change to the regulation, then that recommendation will get forward to the board, and then the board would have the authority to discuss that and then adopt that or not adopt that recommendation. On page 4 of the packet, there's some additional information if you want to track the process by which a regulation is changed. There was a bill that was passed earlier this spring that changed some of the regulatory process. So we'll need to go through and update some of this information. But in general, it starts with a discussion on the regulation. And then there is a recommendation to change it. The board would have to officially vote to adopt that recommended change. And then we would have staff here at the BSRB go ahead and write up the recommended change in the language and then submit that to certain offices for review, and then they would provide us additional comments back. There is a specific legislative language standard that we have to follow for a lot of our statutes and regulations, so sometimes that can affect the actual phrasings of the regulation. If you turn to page 6, we'll talk a little bit more about some of the other authority for the board and the advisory committees. We've mentioned federal jurisdiction first, and then we've mentioned federal laws. And then we've said that after that, we have the statutes that have been put into law by the state of Kansas, and then we have the regulations. At the top of page 6, it talks about policies and where they come into play. So it says policies may be adopted by a board only to guide its internal operations, such as prioritizing staff workload or explaining the investigation process. Typically, a policy is adopted by the passage of a motion, and then the board may not adopt a policy that would affect in any manner the persons or entities that it regulates. Rather, the board's enforcement or administration of legislation must be properly adopted, filed, and published as a regulation. So there are some limitations in terms of the policies, but those do come under the authority of the statutes and regulations. And those policies are voluntarily adopted by boards to provide a clear standard in certain cases. There are also guidance documents, and it talks about guidance documents a little bit more on page 6. It says guidance documents are documents that state a board's current approach to or interpretation of law or general statements of policy that describe how and when the board will exercise discretionary functions. And then it mentions that guidance documents must be published on the agency's website. And I've mentioned our website a few times before. The website is really a great resource to look at things like the statutes and regulations. Those are all published on the board's website. Additionally, all of the guidance documents and policies of the board are also published there as well. On page 6, it talks about effectiveness as a board member, or in this context, you can apply these as an advisory committee member in most cases. So how to be effective as a board member or an advisory committee member. One thing I would recommend is become familiar with the statutes and the regulations for your profession. And as I mentioned, on the board's website, there's a drop down that has statutes and one that has regulations, and those are separated by the different professions. So when you get a chance, I would recommend going ahead and reviewing the current statutes and the current regulations for the profession, so you are knowledgeable of what is currently in place. It says read all of the board's licensing acts. For your context, I would just start with the marriage and family therapy profession. It may be helpful to look at some of the other professions as a comparison. A lot of the statutes and regulations are somewhat similar in certain contexts, but there are differences based on some of the unique aspects of the profession. It talks about rereading the acts until you fully understand them. And as you're going through them, this is another good opportunity to reach out to someone like me if you have questions, and I'm happy to talk to my staff and clarify anything if you see some unusual language or something that you're unfamiliar with. Be on the alert for agency policies and internal procedures which are inconsistent with or conflict with the board's statutes and regulations, or which affect requirements for applicants or licensees. So we make every effort to make sure that we don't have policies that conflict with the statutes and the regulations. But if you do see something, go ahead and point it out to us, because there may be a situation where we need to make a change to a policy if there is a true conflict. Or it may be something that would be a good learning opportunity for us to clarify sort of a term and explain why that may not be a direct conflict. On page 7, it talks about ensuring that decisions are within the authority granted, and we will do our best to guide you on that. In certain situations, I might jump in and say, it's probably best if we go ahead and take a vote on this issue. Or there might be cases where the advisory committee would want to take a certain action, and I might say, this seems like a topic that maybe should be for the board to discuss rather than the advisory committee. But in most cases, I would say feel free to have open discussions about any topics you think are relevant to the profession. Be willing to initiate action to amend statutes or modify regulation. Even though the regulation may seem confusing, unfair, vague, or overly burdensome to you, chances are good that the persons who have to comply with them also might be confused at some of that language. So if we can do our part to make sure that some of the outdated language is revised or updated, or at least reviewed to see if we need to make changes, that's a good thing that we should be doing. Remember, the purpose of imposing discipline against licensees is to encourage compliance with the law and to protect the public. And then also be mindful that the role of the board is to protect the public and not the licensee. On page 7, it talks about conflicts of interest in a little more detail. It says that conflicts of interest typically mean having any interest, financial or otherwise, direct or indirect, or engaging in any business or transaction or professional activity, or incurring any obligation of any nature which is in substantial conflict with the proper discharge of the board members' duties in the public interest. Board members must make public and recuse themselves from any conflict of interest that exists to ensure the integrity of the board and all of its decisions. And then it outlines some examples of conflicts of interest. There could be personal conflicts, and those are the actions which may ultimately have a personal consequence that is a direct or indirect effect of a decision or action. For example, potentially personal gain. Will this decision affect the board member's personal life, career advancement, or business in any direct way? It could be bias. Does the board member's personal relationship with a licensee in question impair his or her ability to render an impartial decision? Is the board member privy to information about a licensee that the other board members do not know and will affect the board member's ability to vote objectively? On page 8, it talks about the effects of a personal relationship. Will there be an effect on the board member's current, past, or future personal relationship? And one thing I'll say about conflict of interest before we move to the next topic is that if you believe that there might be a conflict of interest, it is always better to err on the side of caution. You just need to verbally say, I'm unable to participate in the discussion on this item or on the vote of this item. And if you know it ahead of time, it's fine to go ahead and outline down at the beginning. If we get into a discussion on a certain topic and you realize about halfway in, you think, I might be too closely connected to this, or based on what people have said, I now understand information I originally didn't. It's always best to err on the side of caution. And if you think there might be a conflict, just go ahead and say, I think I might have a conflict on this, so I'm not going to be able to vote on this item. You don't have to leave the meeting, but it's probably best to not participate in the discussion further beyond that point. And then it's best to not vote if there is an official vote by the advisory committee on that topic. And it's possible that, it may not be an issue, but we would recommend you err on the side of caution. This is left up to the board members and advisory committee members to determine if you have a conflict. So we're going to have you trust your best judgment on this topic. And so it's a lot better to go ahead and make that determination at the front end rather than to look back and say, oh, I regret that I did that. And I would rather, you can't unring certain bells. And so I just err on the side of caution when it comes to potential conflicts. On page 8, in terms of confidentiality, it says at all times the board member must conform to the rules of confidentiality in dealings outside of the boardroom. Protected information obtained in the capacity of a board member must remain confidential during and after board membership, and termination of board membership does not dissolve the board member from responsibility. There's some items on here I'll touch on. Executive sessions during an open meeting. So the purpose of an executive session is to allow the board members to discuss certain matters privately outside of public view. And there is a statute that really talks about what are the grounds for moving into an executive session. One is to get consultation with an attorney on several different matters. One is any potential or pending litigation concerning the organization or personnel. And those topics are all good grounds for an executive session. And so if there is an item that was discussed in an executive session, that should be treated as confidential once you are out of that executive session. And even after your term ends as an advisory committee member, just remember that that confidentiality should continue even after your term on the board or the advisory committee may end. 2, deliberations after a hearing. So if the board has a decision on a license applicant, and that is either a denial of license or an individual has been granted a license with certain conditions, individuals have the ability to request a hearing on that decision. And so when that hearing takes place, the hearing itself is public, but then after the hearing, the board moves into an executive session to do deliberations, and that's a private session for them to deliberate with legal counsel. And so anything, if you were part of that process as part of the deliberations, that would involve a private conversation. And so for most of you, that's not going to involve you. It probably will involve the board more than the advisory committee. However, there's a number of advisory committee members that have gone on to become board members. So good information to hear at this point too. On page 9, we talk a little bit about ex parte communication. That's a pretty legal concept, and I'm not going to go into a lot of detail on that, but the general idea is that in certain processes, such as when a hearing has been requested and we're preparing for a hearing, there may be information where one individual is a party, and then the other individual has legal representation and is also a party in that matter. And so when that process is in place for things such as a hearing, it's important that certain information be received by the board from both parties at the same time, so that there's not an unfair advantage to one side or the other. So there is some language here describing a little bit more about that. That's really not going to involve most of you as advisory committee members, but feel free to read through that section that discusses ex parte communication on page 9. And if you have any questions, just let me know. At the bottom of page 9, there's a discussion about professional activities. And so it says here that a board member may hold an office in a professional or trade association of the regulated profession, but may not lobby for or cast votes regarding a matter that would impact the professional association or the board member's office in that association. The board member may not use his or her position on the board to further the interest of the professional association or his or her office in that association. So we frequently do have questions from advisory committee members that say, you know, I'm a part of this association, but now I'm on the advisory committee. Do I need to resign from that association? And the answer is no. You can be a member of that association, and you can even be in leadership for that association, but you do need to be really mindful of the hat that you're wearing when you're in different groups. And for some people, that may be too difficult to do. So it's really at your discretion, but nothing says you have to resign from that spot. Just be mindful that when you're in these meetings and acting as a member of the advisory committee, are you really thinking with the interest of the board in mind and the advisory committee in mind? Are you doing your public protection mission, or are you potentially influenced by items that may relate to a membership in another organization? And if you feel like you might be, that's a good opportunity to go ahead and say, I think I might have a conflict of interest on this, and then go ahead and recuse yourself from that conversation or that vote. It also talks about board members may attend professional conferences and social events, but they must be mindful about open meeting rules and conflicts of interest if a majority of board members are present, and do not discuss business or affairs of the board to avoid triggering a meeting under the COMA. And I'll talk about that a little bit more when we talk about the COMA in more detail. Under page 10, it says other conduct. A board member should not represent themselves or as a spokesperson of the board unless authorized by a vote of the board to speak on the board's behalf. If a board member is asked to give the board's position on an issue and the board has not authorized that member to do so, the board member must decline to comment or make clear that any opinions expressed are those of him or her alone and not of the board. A board member should not ask board staff or board counsel to provide legal advice or preferential treatment to any applicant or licensee. So one thing on this, so in your capacity as an advisory committee member or in board members' capacity as board members, they might be asked questions about something the board has talked about or something the board has not talked about. And they might ask, well, how would the board feel about this? Or what would the board do in this situation? Or why, did the board do this? One thing I would say is that if you do get approached by members of the public, feel free to loop me in on that conversation, because one of the things is the board often appoints me to speak for the board at different legislative meetings when it comes to budget hearings or bill hearings. And also, I'm happy to go ahead and make sure that any of your discussions as an advisory committee member stay on the server for the BSRB. So that way, if there's any request for records, we can make sure that we have good copies of that documentation too. But in terms of asking about a board's position on a topic, so if the advisory committee has had formal discussions on something, it's always, you're always able to talk about things that have factually occurred. So if there's something, you can always point them to minutes of a meeting or to a broadcast of a meeting. But if it's something that has taken place, you can always say, oh yeah, well, we met on this date and we talked about this, if you feel comfortable with it. But when you're asked to talk about how would the board do this, or would the advisory committee be supportive of this, just be mindful that you're not able to speak on behalf of the advisory committee or on behalf of the board in a future action. But you can say, I'm happy to maybe bring that item to the advisory committee board if you would like to do that. That's a good way to have that item be brought to the board's attention for conversation. You just don't want to be speaking on behalf of the board for an item the board hasn't discussed yet. Now we're going to get into some legal context here. On page 10, we're going to talk a little bit more about the Kansas Open Meeting Act, or the COMA. So this is a statute that allows the public to observe governmental entities making decisions. And it does say that meetings shall be open to the public because a representative government is dependent upon an informed electorate. It talks a little bit here about, as it involves legislative and administrative bodies, both the state and political and taxing subdivisions. But basically what you need to understand here is that the board is a group that would fall under the COMA for most of its meetings, and the advisory committees would also fall under the COMA for most of their meetings. It does not apply to a covered entity when exercising a quasi-judicial function or conducting a proceeding or hearing under the Kansas Administrative Procedures Act. COMA does also not apply to judiciary, private organizations, or staff meetings of a covered entity. So staff meetings of the BSRB are not broadcast. Those don't fall under COMA. Also, if you have deliberations, those are not broadcast. And as far as the quasi-judicial functions for things like hearings, those are open to the public, but there's not the same formalities that have to be followed in terms of providing public notice and different things like that. But for the regular meetings of the board, the regular meetings of the advisory committees, we handle what's required there on behalf of those groups by making sure that when the meeting first started, you heard that we talked about putting notice out and providing an opportunity for individuals from the public to attend this meeting free of charge. So that is something that we take care of on behalf of the board and the advisory committees. A meeting is important to understand. A meeting is any gathering or assembly in person through the use of a telephone or other medium for interactive communication by a majority of members of an agency or public body subject to the act for the purposes of discussing the business or affairs of the public body or agency. And I'll talk a little bit more, and then I'll circle back around and clarify some things on that, because that's something that's hard to understand sometimes. Meetings may be conducted by telephone or other electronic medium, such as Zoom or Skype, if the board complies with all COMA requirements. The name of the gathering is irrelevant, so it doesn't matter if we call it a meeting or if we term it a work session or a retreat. They are subject to COMA. The majority of membership for the meeting is calculated by the next whole number greater than 1/2 the total number of members, including vacant position and absent members. So for us, there are currently 8 members of the advisory committee. So to have quorum, we would need to have 5 members. And that's over a majority of the group. A discussion on page 11 does not require binding action or voting. A discussion can occur at social gatherings, retreats, or meetings held in private, education, conference, and seminars. So you might have some people that say, oh, well, we didn't have a discussion because we didn't vote. Well, under this, discussion is just communication, and so it doesn't have to require a formal vote. On page 11, it talks about the presiding officer has a duty to provide notice of the meeting, but this duty may be delegated. The COMA does not require notice of meetings to be published in a paper or on a website, although we do that on the BSRB website and also the Public Square website for the state. An individual must request notice of meetings to be able to receive the specific notice, and we do have an email list where individuals can request notice, and so we also send out to those individuals too. The notice must provide time, date, and location where the body will meet to the person requesting notice in a reasonable time before the meeting. The COMA does not address meeting procedure, thus the board is not required to follow Robert's Rules of Order or a similar formal rule or procedure. The COMA also does not require the board to create an agenda, but if one exists, it must be made available to everyone. And the public does not have the right to speak, but only to listen and observe. The board cannot vote by secret ballot. So just to let you all know, the board has not adopted a formal process such as Robert's Rules of Order. So the board can reach a decision and the advisory can reach a decision by voting, or we can reach a decision by consensus if it is deemed by the chair that there was consensus of the group. A board policy may require minutes to be kept, but the COMA does not require the board to have a minutes unless there is a motion to go into an executive session. The motion as made must be included in the minutes. And to take an executive session, the board must first convene an open meeting. The board cannot take binding action in executive session, but a consensus is allowed. And then it talks about the 2 most common justifications by a licensing board are personnel matters of non-elected personnel and legal consultation with the board's attorney. Before I move forward, let's talk a little bit more about the meeting definition. So what constitutes a meeting under the Kansas Open Meeting Act? So I'll talk about that again. So a meeting is any gathering or assembly, and that can be in person or over the phone or electronically. So it could include an email if certain things fall into place. It has to be by a majority of members of the agency or public body. So you do have to also have a majority of individuals of the group. So in this case, that would be 5 of the 8 members. And then for the purpose of discussing the business or affairs of the public body or agency. So you have to have all 3 of these for it to be considered a meeting. So sometimes after these meetings, individuals of the advisory committee might contact me and say, I'd like to talk to one specific member, but I'm afraid if I contact them, it would be a violation of the open meetings. That's not going to be a violation because you're not involving the majority of members of the committee. Also, if you happen to run into 5 members of the advisory committee at a social function that has nothing to do with the advisory committee, you don't have to immediately separate. You just have to make sure you don't discuss items that are relevant to the work of the advisory committee, because it has to be a gathering, it has to be a majority of members, and it has to be for the purpose of discussing business or affairs of the public body. So if you have a majority, you have to be careful that you don't talk about items relevant to the work. But if it's less than the majority, you can communicate between yourselves. And also if, you just have to be mindful, it doesn't just have to be in person. I can send you information about the advisory committee. You can always contact me for assistance. But when I send you an email, just don't hit reply all, because if you hit reply all and there happens to be discussion and communication back and forth, even by email, that could potentially constitute a violation of the open meetings rule. So just make sure that you send it to me directly. And in my emails to you at the bottom, usually I'll say, if you have any questions, please contact me directly. So just make sure you don't have communications back and forth outside of a meeting, because those have to happen in a public opportunity for people to hear those discussions. On page 12, it talks about if there is a violation of COMA. It says here that prosecutions under COMA are civil, not criminal. So at worst, there could be a complaint that something didn't follow the COMA. Any person, county, district attorney, or the attorney general may bring an action in district court. The remedies for a COMA violation are listed on page 12. There could potentially be a warning, or there could be a fine. And then it says, effective July 1st, 2015, the Attorney General can enter into a consent order or issue a finding of a violation. We will do our best to avoid any issues with the Kansas Open Meeting Act or there being violations, but I just wanted you to be aware of some of those potential issues in case there is a violation of the Open Meeting Act. On page 13, let's talk a little bit about the Kansas Open Records Act. So the KORA, or the Kansas Open Records Act, is a law as well, and it requires the board to have its records open for inspection by any person unless otherwise provided, and KORA shall be liberally construed and applied to promote such policy. A public agency includes the state or any political or taxing subdivision of the state, or any office, officer, agency, or instrumentality thereof, or any entity receiving, expending, or supporting in whole or in part by public funds appropriated by the state political taxing subdivision. The thing to take from that is that the board and the BSRB and the advisory committees would fall under KORA. So if somebody made a request for records under KORA, most of the information we would have to provide. Now, there are certain exceptions, and we'll talk about some of the information that we might have to redact or not provide. On page 14, it says a public record includes any recorded information, regardless of form or characteristic, which is made, maintained, or kept by or is in the possession of any public agency, and written records, photographs, computer data, and email. A public record does not include records that are owned by a private person or entity and are not related to the functions, activity, programs, or operations funded by the public funds or records and not in existence at the time of the request. Under the KORA, the board must appoint a Freedom of Information officer to assist with KORA request, display, distribute, or otherwise make available a brochure describing requester rights, agency responsibilities, and procedures, inspecting or obtaining copies of public records, and include the name, title of a records custodian, fees, and office hours available to anyone upon making a request. So for the BSRB, we handle these KORA requests. In our office, by the front desk, we have a copy of our open records request policy, and that is posted there, and there is a form individuals can fill out, or they can just send us a message that says this is an open records request for X data. Now, there are certain things in the KORA that you do have to provide, but they do say it should be liberally construed. So our responsibility is that when we receive a KORA request, we have 3 days to send back a confirmation that we received that. And if we have the information, we should provide it. But if we need additional time to research that data or collect it, we can have that time to collect that data too. And we will turn that over to most individuals. But the reason I'm bringing it up here is just to make you aware, as you all are professionals, I'm sure you're familiar with records and different things in that context. Most of the work of the BSRB and the advisory committees, this information would be available if we had a quora request for certain documentation or records. So this is just a good opportunity to remind you that when you're communicating back and forth, just always stay professional. One thing when I worked for the legislature before I had this position, they always said, just imagine that any email you send could be put forward in a committee or, could be in the paper. And so just be mindful of the way that you communicate and that knowing that most of this information could be turned over if someone did a records request for some of this information. Now, there is certain information that would not be open. For example, if there's information about a specific applicant, social security numbers, there is also information that is protected as it would involve an applicant and their education records. So there are certain specific items that may have to be redacted, but a lot of the information would be turned over. So I always just try to stress that there is a presumption of openness when it comes to the records. And we do have to turn over records when they are requested in certain contexts. So if you have questions, just let me know, but I'm happy to clarify that. Also, there's certain medical records when our complaint review process does look at certain records for individuals when investigating a complaint. Some of those might also be redacted or not be able to be turned over. And then there also are legal communications from our legal counsel. Some of those might not be things that we would turn over, and they might be exempt from some of these. But the main takeaway is that most of the stuff we talk about, most of our records would be available as a quora request. On page 15, it talks about some of the cost. We are allowed to charge for some of the cost if there's a lot of records that we would be turning over. There would be staff time to go ahead and put that together if there's a lot of information that's requested. On page 15, it also mentions quora is a civil act, not a criminal act. And then there's some information there about the quora. On page 16, there's information about the Kansas Administrative Procedures Act, or the CAPA. This is something that is used when we are discussing individual applicants before the board to have a board's decision on if an individual should be licensed or not. In certain statutes, it mentions that in certain cases, for example, when someone has felony conviction, those applicants have to be reviewed by the board to see if they meet the qualifications for licensure. Also, the discussions by the Complaint Review Committee, those fall under the CAPA and would also be confidential. Now, once a decision had been issued, if the individual didn't appeal that decision, it would become public, and any public discipline records that were final orders of the board are published on the board's website, and you can review those as well. Page 17, there's more information about the CAPA. In most of your work, it's not going to involve items related to CAPA. Most of your work is going to be under quora. So I'm just going to go ahead and say, feel free to review the section on CAPA and let me know if you do have any questions about the data and the documentation that's provided there. On page 18, the CAPA explanation continues. There's a section there about applications, which I've already kind of broadly talked about, and then a section there about the CRC that I've talked about. That's not super relevant to your work as advisory committee members, but let me know if you have questions. On page 19, there's a little bit more process that talks about if items are appealed further in the process, they might go to the Office of Administrative Hearings, and there's some formal processes that are followed through that office. On page 20, there's some information there about presiding officer conduct. There are some different methods we can have. We could have hearing panels for certain decisions, but that's really going to affect more of the board than the advisory committees. So most of that information you can go ahead and review. Just follow up with me if you have questions. But the last item I'll talk about is on page 21. So on page 21, we'll talk a little bit about the Kansas Tort Claims Act. At the bottom of page 21, it says the Kansas Tort Claims Act generally governs the liability of the state of Kansas and its agencies or employees. An employee includes a member of a board or a committee of a governmental entity, including elected or appointed officials and persons acting on behalf of the services of a governmental entity in any official capacity, whether with or without compensation. And the basic rule is that the Kansas Tort Claims Act is a vicarious liability for any actionable wrongful act or omissions of a government employee within the course or scope of their employment, subject to the affirmative grant of immunity that exists on a case-by-case basis. The main takeaway from this section is on the next line. If you are sued for an act that occurred within the scope of your duties as a board member, or in your case as an advisory committee member, you are entitled to have the Attorney General's office defend you at no cost. Now, to do that, there are certain processes we have to do, including a request for representation and other things like that. Hopefully that does not come up. It is not something that is frequently looked at, but I want to make you aware of it. So the Kansas Tort Claims Act does cover activities of the staff of the BSRB. It covers board members, and our legal counsel has clarified that it also covers actions by advisory committee members if within the scope of your work as an advisory committee member. So hopefully, as I mentioned, hopefully it will not come up, but I just want to make you aware that in case someone should be unhappy with the work that you do as an advisory committee member and should sue you, we can request representation from the Attorney General's office for that. Now, your main work as an advisory committee member is to do recommendations, and then those recommendations are forwarded to the board for any official action. So it's always helpful to kind of just remind people the scope of their work on the advisory committee. And the work that you do is really important, and it will affect a lot of people. So I do want to thank you for all of the work that you're doing. But I also want to make you aware of these rules just so you avoid any issue. And so now I'm going to go ahead and end the training. And I know that I've presented a lot of information here, but if you have questions, please feel free to let me know.
Thank you, David. Yeah, that was a lot of information to digest. And some of us have heard it before, so it's easier a few times around. But are there any questions, comments from any of the members? I'll just reiterate what David mentioned, which is if you do read through it, have questions on something, please contact him so he can answer those questions for you. So, okay. Well, we will move on to our agenda here. The next item on the agenda was a continued discussion of the unprofessional conduct regulations, particularly for the newer members of the committee. In the minutes was the discussion about the unprofessional conduct regulations review and what particular things we were looking at. And I think we really have done a pretty comprehensive review of those. Our advisory members met and had some things that they would like to make recommendation on. So in those minutes, I'll just refer you back to page 3 of our minutes, which talks about the things that we were most considering, which was record keeping, some issues around boundaries in social media, sexual conduct involving clients, speaking poorly of other practitioners, and a discrimination suggested change. So these will be, I think at this point, I know the other advisory committees are in process of doing similar work. I don't know if they're all done yet. David, you probably told me and I lost that.
Okay, and most of them are wrapping up their work. The behavior analysts are really doing a detailed review, looking at some of their what the association provided in terms of professional conduct. But I think the next step probably is what we're planning to do is if they can wrap up that work this time for the next set of advisory committee meetings, we're hoping to sort of have a document where we can show the different, I mentioned there's some similarities in the statutes and regulations for the professions, but I'm hoping to have sort of a document where we can kind of show the different items that were identified for potential changes by each of the advisory committee members, each of the advisory committees. And then you can kind of see if the same ones that you were looking at were also being considered for changes by other advisory committees. And then that way you can see what changes they were considering and what changes that you have already identified for possible changes. And then the advisory committees can discuss if they want to, maybe consider those further and then move those by the end of the year to the board for the board to potentially review and take action on.
Yeah, thank you very much. So hearing that, there is still, I guess, time, if you will, because we likely will have another advisory committee meeting too before the full board retreat. So particularly for our newer members, the document is attached in your email in the materials for the meeting of the unprofessional conduct standards. So you might look at our suggestions and then also a review of the document yourself and see if you have any feedback or input but we would appreciate your look at it as well. Any other questions, comments about that? Okay, we're going to move into some new business. So we have been discussing the item of a subcommittee for a clinical supervision manual. You may or may not know that not all the disciplines have a board-approved supervisor designation. There are 2, I believe, that do at this point. We are one of them. And we were looking at a suggestion from one of the advisory members that the Social Work Advisory Committee put together a really nice comprehensive clinical supervision manual. It is available on the board website. And this group made a suggestion that we would seek approval from the board to create one of our own that would give a lot of guidance and suggestions. We tabled that conversation because we knew we had turnover and new membership coming on, and wanted to make sure that we had opportunity to invite newer committee members to participate in that work. What my hope is for this committee meeting today is that we could get interest and names of people who are willing to take on that work. David, kind of step in if I'm not adequately describing it, or if there's any other information that I'm excluding in that.
No, I think you described it well. This was something that was a previous recommendation by the advisory committee to form this subcommittee, and that did go before the board. So they did essentially vote to grant approval for the subcommittee to meet. And as you mentioned, the topic for this is similar to the supervision manual the social work profession has. One thing about these subcommittee meetings, even though it's a smaller division of the advisory committee, they would still fall under the Open Meeting Act. And so when membership is determined, what we would probably do is poll those members. What we like to do is we would like to send a doodle poll to the members of the advisory committee when we're trying to find dates for meetings. And so we would send a poll to the members of this subcommittee to identify a date for you to meet and start work on this process. But yeah, I just want to clarify that even though those are smaller sort of working groups of the advisory committee, they do still fall under COMA. So we would need to have these meetings openly, sort of like the advisory committee meetings.
Okay, thank you for that. Do we have any volunteers for interest in working in this activity?
I'm happy to volunteer. I'm probably the newest supervisor on this call, but I'm happy to be a part of that.
Nadine, I was going to say the same thing. I just became BSRB approved this week, actually.
Congratulations.
I've had training recently, but I'd be happy to be a part of it with you.
Good to know I'm not the newest.
Yes, you are not.
A lot of it is statutes and regulations, so I don't think it will really be that in-depth in your supervision. Just kind of how it's set up and any information you want included.
Yeah, thank you, Leslie. And I think, again, there is sort of this nice reference template we could pull from as a starting point so that we could share that document and have that available for us to look at.
I'm happy to serve as well.
Great. That's fantastic, Marcy. Dave, I don't know in particular if I need to be part of that as chair of this advisory committee, or can this subgroup work separately from me?
You know, if you don't need to be officially a member of the subcommittee, we could just have it as those 3 individuals, and then you can attend as you're able to do so.
Okay.
If you want to do it that way. That's what the professional counseling, they also had a subcommittee, but they focused on having one for the unprofessional conduct. And so the chair of that was not an official member, but then she's attending those meetings as she's able to do so.
That sounds fantastic.
Okay.
So thank you for that, volunteering for that task. Again, we do have a nice starting point to really look at how we can help our supervisors with those questions and making sure their training is adequate as they begin this work. So next step, I think, will be the doodle poll then to get an idea of your schedules and frequency of meetings and what those will look like. And then again, that committee work will come back to this advisory committee over time, and we'll share the outputs from that work. Okay, fantastic, thank you. Item B is the discussion of in-residence requirement for KAR 10253. Again, you have this attachment in your packet. Pull that back up here. So I will have Leslie Allen really round out this conversation if she's willing to do so, but this is a topic across advisory committees. At this point, it's been brought up a number of times, and this is an item that also can limit the ability for us, for the BSRB to grant licenses because of this in-residence requirement that's in the regulatory language. So Leslie or David, please jump in and want to discuss this a little bit further. Have some highlighted information for us here.
Sure. And Leslie, feel free to add anything. I'll go ahead and start the conversation on this. So this regulation, KAR 102-5-3, as Mary mentioned, it talks about when an individual applies for licensure, we have to evaluate both the program and also the coursework for the person. And for most of the professions under the BSRB, we have, the board has adopted national accrediting bodies. And if someone received their education from a school that has been accredited by one of those national accrediting bodies, then that's sufficient for a lot of different things. But if someone attended a school that is not accredited by one of these national accrediting bodies, there's some additional requirements that are in place. So in a broad concept, that's why a lot of the different advisory committees for the board are discussing it for the different professions. But there are some terms that are defined in terms of the educational standards for programs. And one of the requirements that has been fairly consistent for a number of years, since about 2004 or 2005, has been a concept called in residence, where a lot of the professions had a requirement that some of the classwork had to be received while the applicant was in residence. And so for the marriage and family therapy profession, if you look at KAR 102-5-3, and I know it's a little hard to follow the legislative style in terms of these numbers, but if you look where it says a little b, about halfway down the page, each applicant for licensure shall meet both the following educational requirements. And then it's number 2, it says the applicant shall have completed no less than 50% of the coursework for the degree, quote, in residence at one institution, and the required practicum shall be completed at the same institution. And then if you go a little above it, if you look at 102-5-3, little a, and then 2, the definition of in residence, it says, when used to describe a student, it means the student is present at the physical location of the institution for the purpose of completing coursework during which the student and one or more core faculty members are in face-to-face contact. And so the main item that a lot of the advisory committees have been discussing and identifying if it is still necessary for the public protection mission of the board, or if it is okay to go ahead and recommend a change, has to do with that part of the definition that says the student is present at the physical location of the institution for the purpose of completing that coursework. And so we have vastly different technology than we had back in 2004. And a lot of the online programs have changed and the standards for those programs have changed. We have a definition of face-to-face now, where we talk about face-to-face can count when you're in person looking at each other across from a table or looking at each other across a screen. You can still be in face-to-face contact by a screen. However, that limitation about being in the same physical location means that a lot of the online schools would not be able to meet the standards that we currently have. And as I have gone to National Association meetings, I've talked to different representatives from other states, and it appears that for most of the professions, this requirement about being physically present is a bit of an outlier. A lot of other states don't have that in their regulations or their statutes. They have other things in place, but as far as being physically present at the school, they don't have that in theirs. And so we seem to be one of the few states that have that. Some of the professions, specifically the licensed psychology profession and also the master's level psychology profession, have talked about that based on the different work that they do or the different types of assessments and training that they receive for some of that testing, they see a value in being physically present for some of that education. But for the other professions, social work, addiction counseling, professional counseling, marriage and family therapy, that requirement of being physically present just seems to be something unique to Kansas. And as Mary mentioned, I think it is causing us that when we have individuals that may meet all the rest of the requirements, we're not able to grant them a license because they weren't physically present at that school. And so we wanted to open up this topic for your discussion. And if you believe that potentially this could be removed where it wouldn't harm the public protection mission of the board, we would encourage you to do that. Because there are other checks in place to verify that the education does still meet a certain standard, but specifically about being physically present. That's the item we wanted to bring forward and request a change if you feel that is something that you're able to do.
Thank you, David. Can I get some feedback from the members here of the committee about the thoughts on this particular verbiage of in residence?
So this would impact only those that are non-COA accredited applicants, correct? In other words,
yes.
Yes, right, okay.
Yeah, there's really once the way the regulations are written, if it is a COA accredited education, there's a bypass. So we take that accreditation standard in lieu of the specific regulation.
Right. I know it's been very problematic I've run into this with people calling from who are doing, I mean, obviously this is about online learning.
Yes.
I personally tend to agree that removing that makes sense.
Yeah, and that face-to-face component also gives the ability for, just like we're meeting today, we can still have that face-to-face component and remove the physical location and still have that measure of assurance that they're receiving the adequate coursework and training. Other thoughts, Nicole?
Yeah, I mean, this is where our world is moving, and especially if we're wanting to improve access to education and increase our workforce, I think we'll be behind the curve if we don't do this. And a lot of professions are moving in that direction and making that possible. So, yep, I agree with removing that.
Marcy, Jim, Jardine, any comments?
I'm just wondering, what's the downside of it? Is there a downside?
Not in my opinion, but I don't know, David, if you can think of a downside for this.
You know, I think I can talk at least a little bit of some of the discussions that I've heard from other advisors. Sure. I've heard individuals talk about, you know, for certain types of learning, some individuals may learn better when they're physically there in person. And that there may be things that are better communicated in person versus on a screen. I guess the other part of that conversation that I've heard too is we're talking about things that are necessary for the public protection mission of the board. So one might be better, but is it necessary? I guess that's the part of that question. You know, some individuals may learn better on a screen. Some individuals may learn better person to person. They're in the same physical presence. The question is this necessary to keep in as a rule to require it, even if it's just something that would be better for certain individuals?
I would just add that I think the more significant part of this is like the hours of practicum that people are expected to do, like how many direct client hours, like having that as a standard for a non-accredited program. To me, that's the most important thing, that we know that they're getting that practice, that oversight, that supervised clinical practice before they graduate. And so to me, the book stuff being face-to-face is not important. And so I definitely am in favor of removing the 50% in residence requirement for non-accredited programs.
Well, and if you wanted to do it really cleanly, just on the physical, being in the same physical presence, what you could do is you could delete, so under that in residence definition, you could just remove the words present at the physical location of the institution for the purpose of. And so if that little part right there was removed, the way it would read is, in residence, when used to describe a student, means that the student is completing coursework during which the student and one or more core faculty members are in face-to-face contact. And since we define face-to-face contact as either in person or by screen, you're still face-to-face. We were removing that little segment of the definition would still leave everything else the same as it is, but it would remove that in the same physical presence requirement.
David, that would be in
I-
addition though, right? Sorry, Marcy. In addition for that definition of face-to-face.
Well, so the definition of face-to-face has already kind of been discussed in the terms of supervision. So I think that's something that, and Leslie, you might be able to help me on this, but the definition of face-to-face, I think we've talked about, either can be physical presence or it can be by screen for face-to-face.
Yes.
Yeah, so I was asking, it would be added, will we add that definition of face-to-face here, or would it just be like as referenced in KAR or whatever?
We might have to add it to this.
Okay.
I'd have to look back and see if the definition, where the definition is stated.
Mhm. Okay.
'Cause usually when the regulations, I believe usually the first regulation is a set of definitions. And then as you go through the rest of the regulations, they might have specific definitions for that section. But that would be the idea, is that the face-to-face would include either in person or by screen. It just would remove the specific language that talked about being in the same physical presence. So.
Okay, thanks.
Marcy, did you have a comment?
No, I was just going to agree with what David and Jardine had commented.
Okay, thank you. You know, I think the only thing that could potentially come up in conversation at a later time is programs that have more, fully online, where they're doing coursework that's sort of on their own. I've certainly heard some discussion about that, but in this particular case, I'm hearing that we have consensus that we would move this recommendation forward. Is that what I'm hearing?
You want a motion?
I think we have consensus, so David will
Okay.
let me do consensus for this discussion. I
Okay.
think he'll always correct me if I'm misstepping. Great, thank you. That's great. We'll take that to the boards and see what the other advisory committees are coming up with as well. Thank you for that discussion. We have the next item is the discussion on licensed psychology, KAR 102-15. This is about continuing education documentation. So David, you might have to help me with this conversation, but if someone failed to get all of their continuing education during their renewal period, there was a grace period. Is this what this is in reference to?
Sort of, yes. I'll go ahead and
Okay.
share my screen here.
Please, yeah, go ahead.
Okay, so you should be seeing a copy here of continuing education regulation, KAR 102-1-15. And so this is a regulation for the licensed psychology profession only. And so basically all licensed psychologists come up for renewal in June of even numbered years, which is a little different because everyone else, it's 2 years after they were licensed. But when we were preparing for all of the licensed psychologists to renew, there's a regulation under continuing education, which is 102-1-15G. And I'll go ahead and highlight that on the second page of the document here. And so it says any applicant who submits continuing education documentation that fails to meet the required 50 continuing education hours may request an extension from the board. The request shall include the applicant's reason for requesting an extension and a plan outlining the manner in which the applicant intends to complete the continuing education requirements. For good cause shown, the applicant may be granted an extension which shall not exceed 6 months. And so essentially in statute, it outlines the licensure period is 2 years long. So we can't extend someone's license, but what this allows individuals to do, normally you would not be able to renew your license unless you had completed all of your continuing education hours. So under this, if individuals were coming upon their deadline to renew and they had not completed their hours for the licensed psychology profession, and they had good cause for needing an extension, they could request an extension from the BSRB. We reviewed those applicants, and then if they met the standard, we could go ahead and provide an extension of time, which would allow them to renew their license and then go ahead and finish those hours after they had renewed their license. And so this regulation has been in place for a number of years. As you can see at the bottom, the last time this set of regulations was changed was back in 2003. So it's been in place for a number of years, but generally we've only used it when individuals contacted us and then requested to use it. Well, we had concerns about individuals dropping out of the profession. And so about a week before the deadline, we sent a message to all licensed psychologists who had not renewed their license, making sure that they were aware of this. And we said, you know, we know there might be individuals who, because of the pandemic or other reasons, were unable to complete all of their hours and they might qualify for this. So if you would like to continue to practice in Kansas, we want to provide a way for you to continue to practice and then still make sure that you complete your hours. And so using this aggressively, we were able to help about 10 to 12 licensed psychologists get renewed and continue to practice when they otherwise would have just let their license lapse and stop practicing. And so I shared this with the board at the last board meeting, and the board thought it might be interesting for the other professions to consider, would you want something like this for your profession as well? As I mentioned, this regulation is only in the licensed psychology regulations, but I can see merit in other advisory committees discussing this and possibly recommending some similar language for their profession. So how we are treating this, just to let you know kind of how we're working through this with those individuals. We kept a list of those individuals. We went ahead and granted them all the 6-month extension. We are following up with them at least by 5 months into the process. If they have not notified us about their completion of the hours by that point, we are giving them a reminder to make sure that they all complete it by the necessary time frame. As part of this process, they did have to send a plan to us outlining how they plan to complete the hours. So there are some checks in place. And, you know, unfortunately, should individuals not complete it within the 6 months, how we would handle that is we would file a report of alleged violation against those individuals for not fulfilling their requirements under this. But we see a lot of benefit in helping individuals who want to continue to practice stay licensed under the board. And so we wanted to bring it to you for your discussion. So I'm happy to clarify anything on that, but want to open up for your conversation on that topic.
So I think where, if you could sort of help me understand in terms of renewal, and someone failed to meet there, what would you do with the audit process? So again, advisory members, for those who are licensed, know that there's always an opportunity to be selected for audit. Following a license renewal, would that be then an opportunity, if we had such language, to provide a plan versus a report of alleged violation moving forward?
So yeah, under the current system, when individuals go to renew their license, they have to attest that they have completed all of their hours. And then 10% are randomly selected for audit. And at that time, they have to show that they had completed all of their hours based on the audit. Now, if you submit a renewal and you indicate that you had completed less than 50, then you are automatically pulled by the renewal specialist, and then they contact the person to follow up with them. So under this, they went ahead and put down whatever hours they had completed, and they were able to renew, and normally those would be pulled, but the renewal specialist was able to go ahead and release them from where we would currently have them selected. And then they essentially communicated with me. It was a small group of people. So if we were going to expand this, we would need to change some procedures as far as how we would implement it. But essentially, they received additional time to complete those hours. Otherwise, normally they would be in the audit process with our renewal specialist. So instead of being held, they were released and they could just have their license, but then they had additional time and some framework to complete the hours.
Was the question changed on the attestation to say I've completed my hours, or is the question I haven't completed all my hours, I've completed 32 of 40?
So for theirs, they were able to go ahead and put in how many hours they had completed.
Okay,
So they were able to move forward with the renewal process. And then if they put in a number fewer than 50, then they're automatically pulled. So this, yeah, you're right. Basically, in other circumstances, you wouldn't be able to do your renewal because you had to attest that you had met all those hours. And so we would have to change a couple things on the form for the renewal, but that's how they move forward in this case.
Any discussion offhand, right off the bat? I know we're running close on time. So are there any thoughts we want to solidify real quickly before we likely put this on to our next agenda?
It sounds to me like it would add a lot of staff time. Like additional staff work
Mm-hmm.
to do. It also seems like a concern for me is when you're left for a good cause, who determines what good cause is?
So that was something that we had determined in the past as far as good cause. And we talked about that language really could be changed if we wanted to expand this. We could do it to some of the other language that's more used by the board, such as extenuating circumstances. So we could make it more simple.
Still has, I mean, someone still has to determine, which is Dave's lucky position.
Right, and so that determination is really left to the BSRB right now. And most of the items, when people indicated they submitted something related to the pandemic. And so even though things have improved, that was what we were really looking for in this case. So we probably want to change that definition going forward to something like extenuating circumstances, and then be able to evaluate them, hopefully, as we continue to improve from the pandemic.
David, did I hear correctly that the process was that the staff contacted them? Would it be possible to have it where the action is from the person seeking license? So if they realize that they are not going to have those, that they fill it out and they reach out with a description of their extenuating circumstances, rather than it be the staff who looks and says, oh, this person didn't meet that requirement.
Yeah, and I think that's probably how it would be going moving forward. In this case, we had a lot of concern. SIPAC had just passed this spring, and we were concerned that we would lose a lot of licensed psychologists due to that. And the number did drop from about 1,050 down to about 950. So we did lose quite a few licensed psychologists, not all because of SIPAC. There's usually some decrease when they all renew. But we wanted to be aggressive to try to keep people licensed if we could. Based on knowing we were going to lose people because of the compact, but also just because of retirements and other issues. And so I think in the future, instead of sending it out to them, we could maybe add a note or let them contact us if they wanted to request to use it under this.
I know we're like 37 seconds away from ending. I'll just add, I'm in favor of allowing for the flexibility, but I didn't even consider Chris's point about staff time. And I think to that point that maybe there's a different way that we would want this enacted, where maybe we just need to keep people informed that this is an option. Like maybe it's just sent out 2 or 3 times a year as a reminder that you know, if your renewal is coming up and you are short on time, that there is an extension available and here's that process, rather than seeking out people like you were just saying, like that was a special circumstance. But I think people would need to just be kept aware that this was an option because for so long, it's not been an option.
It
So
would
I'm
be,
in favor of it.
yeah. it
My
would
quote-
be, so.
My question is, what happens if it becomes habitual? And that, they always can say, this option's here, so I'll use it all, and just wait till that time and then pick it up later than the date.
Yeah, good point, Jim. I always say people are habituated creatures, right? And so that idea of thinking there's an extension might become something different. So I think this is great discussion and I appreciate your comments. It will be our business to tackle for the next meeting. While we have just a second left, if I could ask everyone to look at your calendars for October. The targeted date, if we stayed on the same frequency, would be October 14th, 10 to noon. David, were there any conflicts from your end on October 14th?
October 14th. Nope, no, we're wide open that day. So
Okay. How does that look for the other committee members? Jardine's given yay. Nicole's yay. Jim's good.
I have a travel day to, I made, I'll work on it.
Possible.
Yeah.
Okay, possible.
Is that, do we anticipate that will be virtual again? I could do
Yes.
virtual, but then it'll work.
Yeah, I think David and I have spoken at least through the end of this year, and that we would continue and then bring it up for discussion next year. I personally favor these meetings because of time and drive and all of those things. So, but yes, we'll bring that up at the beginning of next year. So let's try for that. Chris, I'm hoping you can make that happen. October 14th, 10 to noon. Let's target that date. And if there's no other business, I'll take a motion to adjourn, please.
So moved.
Second?
Second.
Okay, all in favor?
Aye.
Have a great weekend. Thank you all for your participation and welcome to our new members.
Thank you.
Thank
Bye.
you.
Bye.
Okay.